Hello and welcome to Triage, rapid legal lessons for busy healthcare professionals, a podcast created and produced by K&L Gates. Each episode is designed to highlight important developments in health law and analyze the impact on our clients and friends of the firm. We hope you enjoy this podcast.
Hello, and thank you for listening to this Triage podcast. I am Gary Qualls, a K&L Gates partner. I litigate and arbitrate healthcare disputes, and in this podcast, I attempt to distill a provider-payer dispute of interest. Today's case is Michael P. versus Blue Cross Blue Shield of Texas, a federal district court case from the Western District of Louisiana. I've isolated this case for attention because it shows that the gauntlet of the arbitrary and capricious standard does not always result in frustratingly blind deference to payers. For more details, I've provided PowerPoint slides. This suit arises from the denial of coverage for acute inpatient mental health services for the plaintiff's minor daughter, we'll call the patient. The patient was admitted to the Menninger Clinic, we'll call the facility, in Houston, Texas in late January of 2016 for inpatient mental health treatment. Blue Cross of Texas provided coverage for 11 days of inpatient treatment and then determined that further inpatient services were not medically necessary, although the patient continued to receive inpatient treatment. Blue Cross cut off payment despite, as you'll see, the patient continued to need inpatient treatment for a variety of reasons. The plaintiff, the father of the patient, appealed the denial of benefits through internal and external review procedures with Blue Cross. He then filed this suit in the federal district court, alleging the denial of benefits was an abuse of Blue Cross's discretion. As listeners familiar with health plan appeals know, that all too familiar term, abuse of discretion, often means the insurance company can get away with just about anything. Fortunately, not here. The court addressed whether Blue Cross acted arbitrarily or capriciously in determining that the patient's inpatient treatment was not medically necessary before the 11 days Blue Cross was willing to pay. The non-covered period was 39 days, from early February to mid to late March. Blue Cross used the Milliman Care Guidelines, we'll call the guidelines, to evaluate the medical necessity of the patient's treatment. Under the relevant guidelines, inpatient treatment is considered medically necessary if a patient risk exists and the treatment situation is appropriate at that level, i.e. the condition excludes a lower level of care, here which would be outpatient care. Inpatient care would be justified upon an imminent danger of harm to self where at least one of the several listed conditions is present, including where there's imminent risk for recurrence of a suicide attempt or act of serious self-harm as evidenced by the patient's very recent history of suicide attempts or acts of self-harm, and absence of sufficient relief of the action's precipitants. The heart of the dispute. The father's dispute was with Blue Cross's findings that the patient's condition had improved sufficiently as to her danger of suicide or self-harm by the last covered date. So the father argued that based on the patient's history and the record of her care at that facility, there's insufficient evidence to show that her condition no longer required inpatient care by that cutoff date. Multiple suicide attempts. The record showed the following. The patient had multiple suicide attempts and DUIs in the year preceding admission. Her last suicide attempt occurred just 2 days before her admission to the facility. She had had 4 inpatient hospitalizations for suicide attempts in the last 2 to 3 years preceding this inpatient stay. Blue Cross reviewers conceded suicidal tendencies in late January. According to Blue Cross, the patient met the guidelines for admission to inpatient care on January 27 and was renewed, but for only another 5 days on February 1. On both dates, the reviewers specifically noted, among other things, ongoing suicidal ideation after the patient's most recent suicide attempt and severe symptoms as evidenced by paranoid and auditory hallucinations, impaired insight, judgment, and coping skills. The Blue Cross reviewer found that inpatient care was not medically necessary past February 5th and that the patient could safely be treated in a lower, i.e. outpatient, level of care. In contrast, the patient's treating psychiatrist and treating psychologist at the facility both opined that the patient's inpatient treatment was appropriate in terms of type, duration, and level of care for the entire stay, which outlasted the insurance by 39 days. Substantial evidence. The court concluded that there was some evidence to support Blue Cross's implicit determination that the patient no longer posed an imminent risk of suicide or self-harm by the last covered date, or that a lower level of care might have been feasible. The question was, however, whether the evidence amounted to a substantial amount in support of a denial of benefits. Blue Cross asserted that allowing the patient's history to guide the determinations would be ill-advised because, under that reasoning, according to Blue Cross, the patient would remain in acute inpatient care for the rest of her life. Blue Cross actually had the temerity to assert that, despite the fact that the patient's inpatient care had in fact concluded less than 6 weeks after Blue Cross cut her off. The patient then completed intensive outpatient treatment without returning to inpatient care. Further, the records showed that the patient had improved dramatically since her treatment in 2016, no further suicide attempts, and would soon be graduating college. The patient's treatment providers at the facility endorsed a longer stay, believing that her recurrent suicide attempts required acute inpatient care and could not be addressed through a short-term stay or lower level of care. The patient's evaluations from around the time of the last covered date showed only modest improvement, and she was not downgraded to the lowest level of responsibility at her acute care facility until February 17th. While the patient denied suicidal ideations and appeared to be adjusting well to the program, she was still severely depressed by the last covered date and expressed ambivalence on her desire to live or die. Reviewers' false conclusions. The insurance company reviewers seem to have seized upon any indication that the patient did not have active suicidal ideations as signifying an end to the risk that had justified her admission, even though the following facts were true. First, there were clear signs that she still relied on the restrictions of an inpatient setting. Second, she had attempted suicide again after several prior inpatient stays. Third, her treating providers did not believe she could stop her cycle of suicide and self-harming behavior without a longer stay. And finally, her treating psychiatrist believed that she posed an increased risk of completing suicide based on her history and comorbid substance abuse disorder. While the internal review organization, IRO doctor, acknowledged some of these factors in his rationale for allowing an additional 5 days of coverage, the court concluded that neither he nor the record provided adequate justification for cutting off coverage so far short of the recommended treatment by the treating providers. Instead, the IRO doctor's decision to extend coverage for only 5 additional days stood in direct opposition to these risks and to his agreement that the patient's completed stay at the facility had dramatically altered the course of her illness in a way previous treatment could not. Accordingly, the evidence the court found was insufficient to support a denial of benefits, and Blue Cross's decision would be overturned. The court therefore granted summary judgment in favor of the plaintiff, i.e. the family, so the patient's family won and Blue Cross lost. Some concluding observations. This case shows that even where the standard is deferential toward the payor's reviewing doctors cannot ignore the record and the opinions of the treating physicians, and cannot just institute an arbitrary insurance cutoff date. In a mental health case such as this, it means the patient cannot be cut off by the insurance company the minute the patient stops overtly articulating that they are suicidal, when the patient's overall behavior clearly shows that they are still meeting the inpatient mental health guidelines. Thanks again for listening to this triage episode on recent developments in provider-payor disputes. In the meantime, be on the lookout for the next installment of Triage, Rapid Legal Lessons for Busy Healthcare Professionals. Have a great day.
Thanks again for listening to Triage, Rapid Legal Lessons for Busy Healthcare Professionals. New episodes are available for download through iTunes, Google Play, and other podcast applications. By subscribing to Triage, you will receive timely notifications of each new episode. Also, if you have any topics that you would like to hear discussed on triage, please don't hesitate to email triagesupport@klgates.com. We would love to hear from you.